Adam versus Roxburgh versus Cynthia Richardson. And both sides will have 15 minutes to present their arguments. Attorneys, I'm sure you know that we don't mention children's names. We don't have a victim here, but we don't use victims' names either. And we use either child or, initials. The appellant will have up to 5 minutes for rebuttal, and you just need to let me know as to how much time you want to save.
Very good. You proceed, Your Honor.
Please do, Mr. James.
Thank you very much, Your Honor. If it please the court, my name is Jeffrey James. I represent Adam Roxburgh in this appeal, and I will reserve 2 minutes for rebuttal, and we'll see whether that's even necessary. This is not, good morning, if it please the court. At this point, this is not a case that is very complex. There's not going to be any reference to any sort of children's or victims. This is really a dispute over the interpretation of a separation agreement, which was incorporated in the parties' divorce decree back in July 18th, 2000. And it's pretty clear back at that time, if we look at it, and it's right there in the brief that I filed. All right, there was a paragraph 6 of the separation agreement divorce decree that states what the distribution of the parties' retirement funds are. At that time, Mr. Roxburgh, and he continued to obviously continue in that work and retire from that position. He was working with he had a pension plan through the SERS, School Employee Retirement Plan, our system. At that point, it was in the terms of the separation agreement, it was understood that they would look at the fractional share of his pension based upon the years of the marriage over the years of the service. That would determine the fractional share. And then the provision was, and it states right in there, that it will be offset by the Social Security retirement that defendant shall be entitled to recover from her own employment. Now, understand back in that time, we weren't doing QDROs. QDROs were not an issue at that point. There came a point in time where Mr. Roxburgh, my client, was expecting to retire. That was going to be as of January 1st of the year 2019. Because of that, he received the necessary paperwork from SERS to complete that paperwork with regard to the division of the property and set the offset for her Social Security and the amount that Ms. Richardson would receive. In providing that paperwork to Ms. Richardson, she did not complete that paperwork, did not sign that paperwork at that time, which led to the filing of a show cause contempt citation to try to get that done before January 1st, 2019, when Mr. Roxburgh was going to retire. The court set a hearing that was assigned to a Magistrate Collins, and we have a transcript of the proceedings before Magistrate Collins. I don't think there was any question that it seemed to be clear at that point to everyone, at least Magistrate Collins, that there was an offset for the full amount of the Social Security. And at that point in the course of those proceedings, it was stated by Magistrate Collins that I'm going to direct that we draft a new SERS distribution form or claim form for SERS with the offset provision in there. That would be sent to Ms. Richardson. She would sign it, return it, and it would, of course, then be filed with the SERS.
Now, was that an agreement between the parties or a magistrate's order?
It wasn't even so much an order, because I don't think he ever put the order on. There was a hearing, and the hearing was oral, and it was basically said at that point, this seems to be what needs to be done, and in order to purge the contempt, it was really in order to purge the show cause and contempt, we will draft the new SERS claim form or pension benefit form with the provision for the offset for full Social Security, and that would then be submitted, signed by to Ms. Richardson, signed by her, returned, filed, and everything would go from there.
Well, let me ask it this way. Let me ask it this way then. Was that an agreement between the parties? Did they both sides agree on that, or was that the suggestion of the magistrate?
It was more, I don't want to say it was an order, but it was more like the understanding that this is what needs to be done. And in order to purge the contempt, this is what you have to do.
Okay.
All right. So at that point,
Counsel,
Yes.
I'm sorry. So are you referencing the point at which, is this after the fact that something was written in and she did sign it, right? She signed it, then something was written in. Can you clarify that for me?
that is correct. That is correct, because she did sign the form and she did submit, at that point, she was receiving Social Security disability, and she submitted a form showing what her Social Security disability was. So utilizing that as her Social Security benefit, then an offset, that's right. It was written in at that point. And at that point, then the court said, wait, we want to check on this. And Ms. Richardson said, no, I'm not in agreement. That is correct. I won't deny that. I mean, but understand the provisions, because there was a letter to Ms. Richardson, which was rather detailed, going through the mathematics of that offset, and that letter that accompanied that explained exactly what it was. So there was a
counsel, just so I'm clear. So she signed something. Then something was written in after she signed it. It was she objected. The magistrate then said, type it in and she can sign it. And she still objected on that point. And she did not sign it.
And she did not sign it, correct. After it was typed in, that's correct.
Okay.
But the letters that accompanied it always indicated exactly what the math was. But SERS needed clarification as to what exactly the offset was. So that's why that was added to the SERS form and submitted to the court for signature. That's when they checked with Ms. Richardson and said, no, that's not my understanding at all. Even though that was in the letter, that was not my understanding. And that's when it came back to the court. And that was before Magistrate Collins, and Magistrate Collins indicated that seems to be the clear language of the separation agreement, that it should have this offset. I'm going to ask that the form be now not handwritten, but that provision be typed in it, submitted back to Ms. Richardson, and you will then proceed to sign that, and that will purge any contempt. And we would withdraw the contempt, and we agreed, we're not even asking that cost be assigned to Ms. Richardson or anything of that sort.
So your argument was that this was in this provision in the separation or the divorce decree included not just Social Security retirement, but also Social Security disability.
Well, yes. And that was an argument that was kind of somewhat raised about, well, we don't know exactly what her retirement benefit is. And I said, well, you can get that retirement benefit. She can, we can't. She can get that by requesting it from Social Security. She gets an annual statement, provide us that annual statement, and we'll use that number. But disability, the Social Security disability and Social Security retirement, based upon what you pay into SER or into the Social Security system, are very similar. And the idea that, are you saying that if he was going to retire and she has not yet retired, started to receive a Social Security benefit, he receives no offset for all those years until such time that she does decide to retire and start drawing Social Security? That would, of course, make no sense. Does that answer your question?
Oh, it answers it.
Yeah, I mean, that would make no sense to simply delay it, all right, and say, we're not, I'm sorry, but he has to pay the full amount with no offset whatsoever until such time that she starts to draw her Social Security. I mean, the other side would, what if he had done the same thing? I'm not going to retire right now, and she would, at some point, I'm not going to start drawing my SERS, and at some point in life, she might come to say, wait a second, you can't just simply put that off forever and thus negate the provisions that I should receive benefits under SERS. That would make no sense in reverse. So you have to use an offset amount of some sort. And we were just asking what her retirement benefit was. The only document received was that she was receiving Social Security disability, which would be a similar amount to that. And if it changes over time, then adjustments can be made. The issue, very simply in this case, is how do you interpret paragraph 6? Understand the court has no authority. No court has authority to simply modify on its own the terms of a separation agreement. it's clear that a separation agreement is a contract. I believe in contract. We follow contracts. This is the agreement that the parties reached. And the parties reached at that time that there would be this offset for Social Security. Surely they had the ability at that time to understand that they could use a fractional determination. They used a fractional determination in deciding how they would distribute the SERS. Why could you not say the same thing with regard to the Social Security? But they did not. That's the clear language of the agreement. There's no ambiguity in that agreement at that time. They had counsel. It was adopted. It was signed. And to now suddenly go back and say, well, as a matter of equity, somehow we need to adjust that or change that, that modifies the parties' agreement. And that's exactly, no question that Magistrate Collins believed this is the clear language of the contract. That ended up going to Judge Quinn. For some reason, he decided to take the matter over. I'm sure I know why, because he felt that he wanted to be more equitable. And therefore, I wanted to go ahead and do a QDRO analysis like we do today and apply that retroactively to an agreement that was signed back in 2000. And so we're going to do this QDRO analysis. Surely even though we ended up saying we'll agree to do the analysis, we're not in agreement with the outcome, but we'll agree to do the analysis to see what it is. And it turns out that the analysis is paying her $900 and some as the amount that she should receive under SERS, versus if there was a full offset for Social Security, it would be somewhere in the area of just short of $400. It'd be about $390. I have those.
Counsel, you have about 4.5 minutes left.
Yes, and thank you very much. The point is simple, and it really is one point, and that is there an ambiguity here that opened the door for the court to make an interpretation? It's our position that there was no ambiguity here. Thus, the court was not in a position to, on its own, just decide that it was going to do what it thought was right or equitable, all right, in contravention to the Mr. Roxburgh, all right, and his rights, and they proceeded to do so. Understand that if Mr. Roxburgh back in 2000 was under the understanding that there would be this offset substantially less, all right, than Social Security, than the full Social Security, then that would have changed the negotiations back in 2000, or could have changed the negotiations. He may have at that point, knowing that she was claiming more funds out of the SERS, decided to pay some sort of benefit to her, some sort of bonus. We see that happen all the time, all right, where we're going to give you some other lump sum payment, all right, in lieu of this claim. But all of that was taken away from Mr. Roxburgh. He never had that opportunity to discuss that because no one interpreted in 2000 that there was going to be a different offset than what is clearly stated in the separation agreement. So it's our position that there is no ambiguity here. The court decided to do something on its own and interpret this paragraph 6 completely different and in contravention to what it actually says, because it thought that it somehow wanted to be more equitable, apparently. And that was just wrong. It's erroneous for a court to do that.
Thank you, counsel.
Thank you.
Mr. Hawkins, you have 15 minutes. Don't forget to unmute yourself, Attorney Hawkins. Thank you. There we go.
If it pleases the court, my name is Jeff Hawkins. I'm with the law firm of Slater and Zers, and I represent the appellee Cynthia Richardson. I first want to note that the hearing that counsel mentioned with Magistrate Collins, my client was unrepresented in that hearing. When I became involved, Judge Quinn became involved almost at the same time. At the hearing where the judge suggested that we get Quadro Group involved, no one objected to that proposal. Quadro Group was provided my client's Social Security annual statements. They did a thorough analysis as to my client's retirement benefits, as pertains to the division of property order and the language in the original divorce decree. The offset that was originally included in the division of property order was my client's disability retirement, not her retirement. So our position is the disability has nothing to do with this case. It's a separate issue. Quadro Group was hired. They did a thorough analysis as to the Social Security offset, and they prepared the appropriate division of property order. Clearly, the language of the original divorce decree was taken into account, and the contract language was abided by. The retirement offset was appropriately calculated in the DOPO. The analysis was entered as an exhibit for not only the trial court, but for this court to review. So I don't think there was any error in Judge Quinn approving the division of property order. The appropriate retirement offset was given analysis by Quadro Group. That was part of the record. So unless the court has any questions of me, I ask the court to affirm the judgment of the trial court at this time. Thank you.
Judge Theodosio or Judge Sutton, do you have any questions of Mr. Hawkins?
Well, do you agree that the court did not have authority to modify if there was?
Pardon me?
Do you agree with Attorney James that the court did not have authority to modify if the language in the original separation agreement was clear and unambiguous?
I agree with
that. Is the law, right?
I agree with that, and the court abided by that language. That's our position.
Anything else? Judge Sutton?
I have no questions.
Okay. All right. Well, Mr. Hawkins, thank you for your presentation.
Thank you.
Mr. James, you still have 2.5 minutes remaining if you'd like to take them.
I will, Your Honor. Real quick. First off, they raised that as a red herring that there was no objection to the Kudrow analysis. Look, in the course of law, we always try to get along. The court suggested that we do a Kudrow analysis, and we said, fine, we'll proceed to do a Kudrow analysis. Doesn't mean that we agree to abide by their adoption or whatever their recommendation. We opposed that all along and made that clear on the record. All right, if that turned out to be something that was not agreeable. If they had come into an amount that might have been close or somewhere in the middle, there may have been an agreement reached. So the idea that somehow we agreed to the Kudrow analysis means that we did not preserve our objections is just error. Secondly,
Counsel, let me ask you this though. An argument could be made, and maybe that's what Mr. Hawkins is saying, by agreeing to the Kudrow analysis, you are actually agreeing that the provision was ambiguous.
No, not at all. That's part of negotiations, just like like when you're doing a settlement. We're fine, go ahead and do a Kudrow analysis. We'll see what the analysis comes out, and then we'll go ahead and decide at that point whether we want to, depending upon what it is, whether we want to adopt that as part of our settlement or whether we don't want to adopt that. Settlement negotiations have nothing to do with the final outcome or not preserving your objections. And surely the record is clear that with Judge Quinn, that when he went to adopt that, we were clear that we're opposed to that and we object to that. There's no question about that. With regard to the issue of disability, you have to do an offset. We're asking, tell us what the offset is. And what the Social Security retirement benefit is that she is to receive, and we will proceed to, at that point, do the offset based upon that. The only information provided to us was the disability, which is close to what the retirement benefit should be for someone in Social Security. But the idea that somehow if I'm not receiving Social Security retirement, that there would be no offset until such time that I do, that's absurd. Because that would be a windfall to Ms. Richardson to receive, the benefit of no offset until such time that she is going to receive Social Security. The language is clear that the defendant shall be entitled to recover, that there would be an offset for the Social Security retirement, that defendant should be entitled to recover from her own employment. Makes no provision for offset, doesn't say anything about Kudrow because we weren't discussing Kudrows in 2000. right? It just talks about the fact that she is offset for her Social Security, and that's what's in there. They made provisions for a fractional share distribution of his SERS. They could have done the same thing in the language of in that clause with regard to her Social Security, did not do so.
Counsel,
And to that's fine.
please wrap it up. That's all right.
No, in light of that, Your Honor, we're asking the court to find that there is no ambiguity here, that it was error for the court to simply adopt a Kudrow because it thought that that was somehow better, all right, in contravention to Mr. Roxburgh's rights, all right, and we're asking the court to send this back for a revision of the journal entry and that a determination that the proper offset is the Social Security that Ms. Richardson is receiving, and she can provide us with that information. Very good.
Thank you, counsel. Thank you both for your arguments and presentations to the court this morning. You know, the court will take the matter under advisement, and we will issue a written opinion that will be sent to everybody by the clerk of courts. But you can also check in 2021 all of our websites, our website and the Supreme Court website, so that you'll know when it's actually electronically released.